in the case of Palm Beach County School Board versus Diane Bauman, DOAH case number 22-2601, TTS, Robert L. Kilbride. This case involves the suspension and termination of Diane Bauman. Would you all please stand for the pledge? I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Would the board clerk please take roll call?
District 1, Barbara McQuinn is absent. District 2, Alexandria Ayala.
Here.
District 3, Karen Brill.
Here.
District 4, Erica Whitfield.
Here.
District 5, Frank Barbieri.
Here.
District 6, Marsha Andrews.
Here.
District 7, Edwin Ferguson.
Right, we have quorum with 6 board members present. General Counsel?
Thank you, Mr. Chair. I know you all reviewed the records, which included a letter to you outlining detailed information regarding the scope and parameters of this exceptions hearing today. I will go over where we are procedurally, the board's charge and responsibility in an exceptions hearing, and the legal standard for voting. After I go through all of the information, I will then entertain any board questions before we proceed. You will then make some decisions regarding this case. This case is before the school board for review of the recommendation for suspension and termination of Diane Bauman for ethical misconduct, failure to exercise best professional judgment, failure to follow policy, rule, or directive, and gross insubordination. Ms. Bauman requested a Division of Administrative Hearing, DOA hearing. She was represented by attorney Mark Walensky, who's seated here today at the hearing before the Administrative Law Judge Robert Kilbride on April 27th and 28th of 2023. Also seated before you is Jean Marie Middleton and attorney Danielle Williams, represented the superintendent at the administrative hearing, and Ms. Middleton and Ms. Williams do so as well today. As provided by law, since the ALJ issued the recommended order, I have not conferred with Ms. Middleton or Ms. Williams substantively regarding this case. After the DOA hearing, the administrative law judge concluded that Ms. Bauman committed ethical misconduct, failure to exercise best professional judgment, and failure to follow policy, rule, or directive. He recommended that Ms. Bauman serve a 20 to 30-day suspension without pay, receive remedial training related to appropriate interactions with students, and serve a 6-month period of probation when she returns to work as a last chance to correct her conduct. He rejected the superintendent's recommendation that Ms. Bauman's employment be terminated. The superintendent timely submitted exceptions to the recommended order. He is now before you on 6 exceptions and is requesting that the school board grant those exceptions and thereby enter a final order upholding the superintendent's recommendation for suspension and termination of Ms. Bauman's employment. Ms. Bauman also submitted timely exceptions to the recommended order. Broken down, she has a total of 8 exceptions. She requests that the school board grant those exceptions, conclude that no charges against her were sustained, and order her reinstated with full back pay for the time she has been suspended without pay. The board's review and discussion today is limited to specific subject matter of the issues presented by the parties and their exceptions. The school board has very limited and specific parameters for these hearings as outlined by the Florida sections 120.569 and 120.57 and the Florida Administrative Code. These have been outlined in greater detail in a letter to the board, which counsel for respondent also received a copy of before this hearing. After any presentations of arguments in support and in opposition to the exceptions, board members may ask questions or engage in discussion. You are not required to do so if you have all of the information that you need. With that, the board will now hear argument from the parties on the exceptions. Ms. Middleton is allowed 15 minutes to present arguments. She may request to reserve any portion to reply to Mr. Walensky's arguments. Mr. Walensky is then allowed 15 minutes to present arguments. If Ms. Middleton reserved any of her initial time, she then presents for the remainder of her time. The time clock must be set. No additional time will be provided. Mr. Chair?
Mr. Smell, would you set the time clock to 15? You have it on 10. Ms. Middleton, you now have 15 minutes to present your case, after which Mr. Walensky will also have 50 minutes to present.
May it please the board. Good afternoon. I am Jean Marie Middleton. I, along with my co-counsel, V. Danielle Williams, have the pleasure of representing Superintendent Burke at this hearing. I would like to reserve 5 minutes of my time for rebuttal.
Mr. Smell, make sure the clock dings when there's 5 seconds, 5 minutes.
5 minutes. As you've heard, at the July board meeting, this board approved Mr. Burke's recommendation to terminate Ms. Baumann due to inappropriate comments, including profanity towards a student. Ms. Baumann did appeal, and there was a hearing. You've heard that from our general counsel. The recommended order that was entered on August 18, 2023, specifically stated that you are recommended to enter a final order finding that she committed violations of ethical misconduct, that she failed to exercise best professional judgment, and that she failed to follow policy, rule, or directive. That finding was limited to a single statement to an ESC student of "fuck you." He further recommended that respondents serve a 20 to 30-day unpaid suspension, receive remedial training as to appropriate interactions with students, and to serve a 6-month period of probation when she returns to work. Both the superintendent and the respondent, Ms. Baumann, would like for you to overturn the recommended order. It is the superintendent's position that you overturn the recommended order because you can reject a termination of an employee after reviewing the entire record, which you've been provided, and where you make a finding that your substituted conclusions of law or your interpretations of board rule is more or as reasonable as that you are rejecting. Additionally, the 4th District Court of Appeal has ruled in the case of Dr. William Latson versus the school board in case number 4D20-2577, the Florida 4th District Court of Appeal, November 3rd of 2021, that when an administrative law judge's order has mixed questions of fact and law, and it's filled with policy considerations, the appellate courts will defer to the agency. It's the superintendent's position here today that the recommended order before you is, in fact, primarily one of mixed questions of fact and law, and it is filled with policy considerations. You should reject that recommended order and issue a final order upholding Ms. Baumann's termination. If you would look at tab 15 in your electronic record, pages 1329 through 1346, I will now discuss our reasons for the exceptions. The superintendent takes exception to paragraph 69 of the recommended order, which states, noticeably absent from the evidence was any persuasive evidence from the school board that it seriously considered or evaluated whether some other form or combination of progressive discipline short of dismissal was more appropriate. This conclusion of law is contrary to the evidence and contrary to his rulings in the findings of fact. Particularly at paragraph 14 of the recommended order, he found that Ms. Baumann was an ESE push-in teacher at Canal Point Elementary School. Her work history with the school district revealed that on October 1st of 2014, she received a 10-day unpaid suspension due to inappropriate interactions with coworkers, threats of violence, ethical misconduct, failure to follow policy, rule, or procedure or directive. On January 30th of 2020, the respondent received a written reprimand due to failure to fulfill her responsibilities as a teacher and insubordination. On September 14th of 2020, she received a written reprimand due to failure to complete her job responsibilities and insubordination. He also found that on August the 18th of 2021, Dr. Derek Hibbler, her principal, held a conference with her in which she was alleged to have threatened to physically harm students. He also found that on December 17th of 2021, Dr. Hibbler, her principal, met with respondent regarding her speaking loudly in the afternoons and being confrontational with students. The ALJ also, in addition to this disciplinary history, found at paragraph 16 of the recommended order, likewise, any progressive discipline levied here should consider the challenging nature of supervising teachers and teaching young ESE students. Equally important is the recognition that any person can have a lapse of good judgment in a frustrating moment and make a hurtful or profane comment to another person. She should be given another chance. Ladies and gentlemen, Ms. Baumann didn't have a single lapse in good judgment. She had a disciplinary history of not using good judgment. This was not a one-time lapse. You should reject paragraph 69 also because the ALJ specifically found at paragraph 60 that as demonstrated by the case and in absence of an express list of progressive penalties for a particular offense, there are generally no hard and fast rules for progressive discipline. It is largely understood that the employer retains a fair amount of discretion to reasonably determine what discipline should be appropriate. Again, in paragraph 38, he specifically found, in this hearing, clear and convincing evidence was established to warrant discipline of the respondent for a statement to an ESE student of "fuck you." Ms. Baumann's the board's prior decision to terminate her should be upheld, and you should reject this finding because your actions were made pursuant to your authority under School Board Policy 3.27, Florida Administrative Code 6A-056 sub 2, over which you as a board statutorily have substantive jurisdiction and interpretation. We've also filed exceptions to his paragraph 70, where he says, upon thoughtful and objective consideration, the undersigned does not believe dismissal is warranted under the circumstances of this case for a single proven instance of uttering a profanity. Again, you should reject this paragraph based on her long history and progressive disciplinary record, and for the same reasons as rejecting paragraph 69. We've taken exception to paragraph 71, which states, rather, it is recommended that the school board carefully consider affording respondent a chance to get back on track and continue to contribute to the successful development of ESE students in the school district. As demonstrated in her disciplinary history that he specifically found in the record, she has been afforded many chances to get back on track. We take exception to paragraph 73, 75, and the recommended order that finds that respondent should serve a 20 to 30-day unpaid suspension. She should receive remedial training related to appropriate interactions with students and serve a 6-month period of probation when she returns to work as a last chance to change and correct her conduct. This all should be rejected by you. As I have said before, the recommended order contains conclusions of law that are not based on the evidence in the record as set forth in this exceptions. The superintendent's exceptions are based on the evidence in the record and conclusions of law that are more reasonable than those stated by the ALJ. The conclusions of law in the recommended order are, in fact, mixed questions. He has stated only 1 through 25 paragraphs of findings of fact, but 55 through 75 paragraphs are conclusions of law that are mixed in and some repeated findings of fact from above. We believe, and it's the superintendent's position, that the board's action in terminating Ms. Baumann was made pursuant to your authority and that you are acting pursuant to statute that you have authority and jurisdiction over. And therefore, your prior determination to terminate Ms. Baumann's employment should be upheld. Thank you for your time and for your attention.
Thank you. Mr. Walensky?
Good afternoon. Let me respond as directly as I can. The petitioner first accepts to the finding that the board did not consider discipline other than termination. There's no record evidence that discipline other than termination for this event was ever considered. And the response doesn't, and the presentation today did not point you to any. That's a finding of fact. Either it was considered or it wasn't. You have the record. I know you read it. You can't find it in the record because it didn't happen. The fact that the superintendent's counsel disagrees with the finding and doesn't like it is respectfully irrelevant. Whether evidence is persuasive, and that was the finding, there was no persuasive evidence, is solely within the province of the administrative law judge. The administrative law judge has the opportunity to weigh testimony and facts that you can't do looking at a piece of paper. This board can't go behind the factual determination of the administrative law judge and reweigh the evidence. Clearly and without question, petitioner's exception 1 must be rejected. Not to do so would be error. In its second exception, the petitioner accepts to the finding that termination is not warranted for a single instance of use of profanity. No authority is cited to you which would support termination for a single instance of using profanity. That's because there isn't any. In her response, Ms. Baumann cites to cases decided concerning other school districts on this very point. The precedent of Abrams versus Seminole County School Board is compelling as well as controlling. There, the teacher engaged in excessive use of profane language. It was found that dismissal was neither appropriate nor warranted. The response also cited to a Broward County School Board case involving Alfonso Joseph. It was similarly decided. This exception is not supported by record evidence, which either factually contradicts the finding, nor is there legal citation which would dispute it. Everything before you supports the finding of the administrative law judge. That exception must be denied. Exceptions 3 through 6 can be handled together because it involves the same faulty principle. Counsel essentially tells you that you should increase the recommended penalty because you can. There's no citation or reference to a factual basis found in the record that would enable you to find her position to be more reasonable than the conclusion reached by the administrative law judge based on the facts of this case. Rather than giving you a basis in the record to increase the recommended penalty, there is citation to the governing authority.
Hold on, Mr. Stop the clock for a minute till we get her through this.
I think I read that they're doing this nationwide today to test the system.
Right. I'm sorry, Mr. Wonsky. You continue.
If you'll just give me a second to get back to where I was. Okay, rather than giving, it must be me.
20 minutes.
Rather than giving you a basis in the record of this case to increase the recommended penalty, there's citation to the general governing authority that permits discipline. The fact that you have discipline authority, which is not contested, cannot be a record citation as to why the discipline urged by the superintendent is more reasonable than that found factually to be appropriate by the administrative law judge. With specific regard to exception 3, the superintendent doesn't rely on the allegations and facts of this case. The petitioner doesn't accept to the findings of fact that the issues in this case concern matters which took place in the 2021-2022 school year. That was a finding of fact not accepted to. Instead, the petitioner wants you to revisit decisions made in previous situations, none of which are even remotely connected to the only proven allegation in this matter. 2 of the matters to which you were cited don't even rise to the level of discipline pursuant to the collective bargaining agreement. There being no basis for his recommendation in the actual facts of the case, the superintendent asks you to return to your previous decision. Since there's no other basis which you can follow to fulfill his desires, the superintendent appeals to what he hopes will be your pride in your previous decision. An administrative agency's order increasing a penalty beyond that recommended by the hearing officer can't be based solely on the agency's disagreement with the hearing officer as being too lenient. I cited cases for you in my response. That's what's being urged here. The suggestion is that you already made a determination of penalty. However, you did that on allegations asserted to you as true that were so lacking in proof that the great majority of them were not even presented in the administrative complaint that was actually heard. Those that were, of the two that were, one was disproven. The idea that you should not be open to reevaluating your initial decision after actual proof is misplaced. That analysis plays to your emotions rather than an intellectual evaluation of the matter before you. A desire not to allow yourselves to be further informed by the facts of this case can't be the basis for upholding an exception. The superintendent does not accept to those conclusions of law, which you must therefore accept as the law of this case, which point out that there is no formulistic requirement that you must move to termination in this case. There's analysis in the response, item by item. To do so, there must be some fact, and that is to move to termination. There must be some fact of this case itself that justifies the discipline to be imposed. There's no fact cited to, nor any existent in this record which would justify the increase of penalty sought by these exceptions. The administrative law judge is independent. He's not an employer of the party urging your actions. You sent the case to him to evaluate the situation fairly and without partiality. He did so, and he made a finding of ultimate fact, not a conclusion of law, as to the penalty that was justified under the facts and circumstances of this case. As we cited in the response, making this determination and recommendation is a question of ultimate fact for the undersigned, as was written by a judge, to determine based on the competent, substantial evidence in the record. That's the Costin versus Florida A&M case that I cited to you. That case held that the administrative law judge's finding as to whether an employee's misconduct justified dismissal based on the terms of the university's, in that case, progressive discipline rule, was an ultimate fact best left to the trier of fact under these circumstances. I also cited the Polk County School Board versus Reagan case for the same proposition. The essence of the argument of the petitioner here is that you have discretion to do as you please. That's not consistent with the law. It's also not consistent with good practice. Your discretion is not unbridled. Your discretion must be exercised pursuant to the law, not by whim and not because we already thought before we heard the evidence that this was appropriate. As was held in Resnick versus Flagler County School Board, an agency abuses its discretion when it improperly rejects an administrative law judge's findings. That's what you're being asked to do here. The exceptions regarding the penalty recommended must be rejected. And as to the penalty, the decision of the administrative law judge, the ultimate finding of fact that he made based on these facts and this case, must be adopted. With regard, I'm going to move on to the exceptions filed by Ms. Baumann. With regard to the first exception of Ms. Baumann, the administrative law judge clearly deprived Ms. Baumann of her opportunity to confront the witnesses against her when he improperly allowed hearsay depositions to be considered in evidence. People throw around that term hearsay all the time. Hearsay is an out-of-court statement admitted for its truth. There is no hearsay exception recognized by the adopted Florida Evidence Code, and I provided you with information on that in the exceptions, that permits these depositions to be considered as evidence. Depositions can be used only in specified circumstances. Counsel for the superintendent cited a case. I'd like you to look at it. That case itself shows the legal infirmity of its position. The case is called Crow versus Lowe. In that case, the Fourth District Court of Appeal allowed a deposition to be used when a subpoenaed witness did not appear because it found that the witness could not be brought to court, and it said, even though the party had resorted to the court for enforcement of the subpoena. That's what you do when your witness does not appear. That's what was not done here. There was no attempt to enforce the subpoena. Instead, just use the depositions. In this case, that simply is not sufficient. According to the record, the witnesses were in school in this very county, in your district, at the time of the trial. 5 adult witnesses from that same school appeared at the hearing. There's no showing that transporting the students was anything but a simple endeavor. Accepting the theory suggested here would render subpoenas for trial to be useless, and it would instead make trials an exercise in reviewing documents and depositions. Exception 1 must be granted. As previously stated, hearings are subject to legal standards. There are specific elements of the law which must be proven, and findings of fact that must be made to support charges brought by a petitioner. The law is overwhelmingly clear that to suspend or dismiss a member of the instructional staff, the school board as the charging party bears the burden of proving each element of the charged offenses. I cited the McNeil versus Pinellas School Board case to you and the Sublette versus Sumter County School Board case to you. The superintendent's claim that there was limited and disputed record indication that Ms. Baumann made a statement did not establish each and every element of what you were told she was found to have done wrong. That has to be had. It wasn't in this case. According to the law, exception 2 must be granted. Exception 3 is mandated because the administrative complaint itself is legally deficient. As paragraph 17 of the exception sets forth, the law requires that the administrative complaint itself advise Ms. Baumann of the charges against her by citing to a specific provision of the Code of Ethics she allegedly violated. If it did, that would have been pointed out to you. It wasn't because it didn't. Look at the administrative complaint. It's in the record. Counsel for the petitioner doesn't even suggest that the administrative complaint is sufficient by citing to a provision of it. Instead, the response to our exceptions claims not to understand the law requiring the need to fully apprise an accused of the charges. Instead, the response discusses proof presented at the hearing. This exception relates to the charge itself and the law involving such a charge. The argument does not address the need to properly charge wrongdoing. That can't be done by citing to proof. This exception involves a failure of sufficient allegations, which must be made before proof can be considered. As the cited case holds, and I'm not reading you citations in my 15 minutes, which is down to 45 seconds to present to you. When there's no citation to a specific provision of the Code of Ethics allegedly violated, the charge was not sufficiently pled to be the best basis of disciplinary action. With 25 seconds left, Ms. Baumann would rely on her written submissions for all other issues raised by the exceptions and in opposition to the position of the petitioner. Thank you.
Thank you. Ms. Middleton, start the clock. Jonathan with 5 minutes.
Ms. Baumann's exceptions in response to the superintendent's exceptions actually support the superintendent's position that the termination should be upheld. The cases that he cited in response to the exceptions, the Abrams case, as well as the State Ex Rel Hathaway versus Smith, were cases from years where the definition of misconduct in office has changed. Recently, that definition has changed. Those cases were based on the definition of misconduct at that time, based on the recommended order and the definition of misconduct in office, which the superintendent specifically found that support the ALJ specifically found support the superintendent's recommendation. Ms. Bauman's case law that she cited in her actual exceptions, again, they're distinguishable from the case at law. He stated that there was no basis to allow the admission of the video depositions. The actual exception reads that there was no basis to allow the video depositions in this manner upon which the administrative law judge relied in determining that she used inappropriate language. Florida Rule of Civil Procedure 1.130A3D specifically allows for depositions to be used for any purpose in a trial when the witness is found to have been unavailable. The superintendent sufficiently demonstrated, and the ALJ found correctly, that the superintendent duly subpoenaed the students, the return of services were made, and they did not appear, demonstrating that the petitioner made a good faith effort to procure the students' attendance at the hearing. There is no finding that there had to be an effort to enforce the subpoena, just that the subpoenas were duly issued and served. And this can be found at your tab 11 in the electronic hearing record, volume 1 at pages 223 through 226. With regard to the second exception, in paragraph 38, that the exception reads, the recommended order fails to find violations of the elements of the charges. Well, he specifically found that there was clear and convincing evidence established to warrant discipline for her statement to the student of "fuck you." The next exception, which is, again, is grouped into a number of paragraphs, 19, 20, and 38, actually, again, support the superintendent's basis. Paragraph 19 says that Mr. Patterson, a physical education teacher at Canal Point, generally supported the evidence from several students. He related that a student told him that respondent used profanity in the presence of several other students, and that she told him he said the F word or something. Mr. Patterson was respondent's witness. He was not a district witness, and he therefore supported. Paragraph 20 and 38, again, we've talked about, where he says that clear and convincing evidence was that she used she made the statement. That part of the recommendation that does not provide for the recovery of back pay that he accepts to in his last exception is misquoted or taken out of context as it relates to section 1012.33(6)A of the Florida statute. Because the recommended order specifically found that she was charged with saying "fuck you" to a student, and the competent, substantial evidence and the clear and convincing evidence found that she, in fact, said "fuck you" to student OD. Therefore, the finding in paragraph 20 of the recommended order should be rejected. All of the exceptions that are set forth do not contradict any of the statements made by the superintendent. The school board of Palm Beach County, you as the board, should deny the respondent's exceptions and enter a final order accepting or granting the exceptions in this case filed by the superintendent and reject the administrative order, therefore terminating Ms. Bauman. Thank you.
General Counsel.
Thank you. At this time, I'll talk a little bit about what's next and involved in the voting aspects. There must be a vote. The vote will be recorded. We recommend first taking a vote on respondents' agreed motion to accept response to exceptions as timely filed. If the board grants either party's exceptions to the ALJ's findings or conclusions, then the board determines that the ALJ made a mistake on this point. If the board grants either party's exceptions to the ALJ's recommended penalty, the board must state with particularity its reasons, citing to the record, but the board need not reject any findings or conclusions in order to increase or decrease the penalty recommended by the ALJ. If the board denies either party's exceptions to the ALJ's finding or conclusions, then the board determines that there are not grounds for modifying or rejecting the ALJ's findings of fact and conclusions of law on this point. The foregoing procedure must be followed for each properly filed exception. The vote on the exceptions will be incorporated into the board's final order. After voting on the exceptions, the board should direct me to draft the final order and submit the final order to the board for adoption at the next available special or regular meeting following the exceptions hearing. After voting on the exceptions, if it deems it appropriate, the board may adopt the recommended order as its own final order pursuant to Florida Statutes 120.57, 1 Florida Statutes. I will now turn the meeting back over to the chair.
All right, at the recommendations of the General Counsel, we first need a motion to rule on the respondent's agreed motion to accept response to exceptions as timely filed, and then on each and every properly filed exception. We have a motion by Vice Chairwoman Brill and seconded by Mr. Ferguson. Any discussion? All in favor? Opposed? Motion carries 6-0. We have a motion. We need a motion based on the General Counsel's recommendation for respondent's agreed motion to accept response to exceptions as timely filed. Motion by Mrs. Whitfield, seconded by Mrs. Andrews. Any discussion? All in favor? Opposed? Motion carries 6-0. Before we go into discussion by the board members, I spent a considerable amount of time over the weekend reviewing almost 2,000 pages of the record, and I'd like to go through my analysis, and then each one of you will certainly have the opportunity to do the same. So I'm going to go through all 6 of the superintendent's exceptions, and then I'll certainly take whoever wants to go next. As to petitioner's exception number 1, which takes exception to paragraph 69 of the recommended order, where the conclusion of the law of the ALJ was that there was no persuasive evidence that the school board considered or evaluated other progressive discipline short of termination. This finding is contrary to the findings of fact in paragraph 12 of the recommended order, where the ALJ recognized that respondent's employment was governed by a collective bargaining agreement between the school board and the Palm Beach County Classroom Teachers Association, school board policies and Florida laws. It is also contrary to the findings of fact in paragraph 14 of the recommended order, where the ALJ set forth a recitation of respondents' past misconduct and the satisfaction of progressive discipline, including 1, the respondent receiving a 10-day suspension due to inappropriate interaction with coworkers, threats of violence, ethical misconduct, and failure to follow policy, rule, or directive. Number 2, a written reprimand due to respondent's insubordination and failure to fulfill responsibilities of a teacher. And number 3, a subsequent written reprimand due to insubordination and failure to complete job responsibilities. In paragraph 56 of the recommended order, the ALJ found that the school board, quote, that the school board and CTA have agreed that the time-honored concept of progressive discipline is the touchstone that should guide any disciplinary decisions, end quote. In paragraph 38 of the recommended order, the ALJ found, and there was clear and convincing evidence to warrant discipline of respondent, and in paragraph 64, the ALJ wrote, quote, respondent's misconduct and the use of profanity directed at a student warrants meaningful discipline that it fits both the offense and, I highlighted this, her past misconduct and discipline, end quote. In paragraph 58 of the recommended order, the ALJ recognized that, quote, 1 act of misconduct may result in minor discipline merely because it was a first offense, end quote, and went on to state, quote, different penalties can be imposed for the same misconduct, again, highlighting depending on the employee's record, end quote. In paragraph 60 of the recommended order, the ALJ found that, quote, the employer retains a fair amount of discretion to reasonably determine what discipline would be appropriate, end quote. Alternatively, in paragraphs 53 through 68 of the recommended order, the ALJ misinterpreted the collective bargaining agreement to require more than the satisfaction of the first 3 steps of progressive discipline and, quote, just cause, end quote, under Florida for termination to be appropriate. The more reasonable conclusion is that the board followed progressive discipline steps as set forth in the collective bargaining agreement in paragraphs 14 and 34, where the ALJ specifically set out the history of the respondent and the collective bargaining agreement's provisions on progressive discipline. Based on the foregoing, the ALJ's finding of finding of fact and or conclusions of law that there was no persuasive evidence that the school board considered or evaluated other progressive discipline short of termination is incorrect. Consequently, after complete review of the record, I believe the board should grant petitioner's exception number 1. As to petitioner's exception number 2, which takes exception to paragraph 70 of the recommended order, where the ALJ found that he, quote, does not believe dismissal is warranted under the circumstances of this case for a single proven instance of uttering profanity on the job towards a student, end quote. The ALJ's finding here is contrary to the facts presented in the record and based on a misinterpretation of the collective bargaining agreement as articulated above. There is no evidence in the record indicating that the petitioner's decision to terminate the respondent is based on only one single instance of uttering profanity. To the contrary, the record reflects that when the school board is imposing discipline on a teacher, the school board is governed by a collective bargaining agreement between the school board and the CTA, school board policies, and Florida laws. As already articulated and acknowledged by the ALJ in paragraph 55 of the recommended order, quote, the school board and CTA have agreed that the time-honored concept of progressive discipline is the touchstone that should guide any disciplinary decisions, end quote. In paragraph 14 of the recommended order, the ALJ recognized the prior disciplinary record of the respondent. It is clear from the record, particularly in paragraph 58 of the recommended order, where the ALJ found that different penalties can be imposed depending on the employee's record. Consequently, after complete review, finally, the ALJ in paragraph 60 of the recommended order found that, as demonstrated by this case, in the absence of an express list of progressive penalties for particular offenses, there are generally no hard and fast rules for progressive discipline. It is largely understood that the employer retains a fair amount of discretion to reasonably determine what discipline would be appropriate. Alternatively, as discussed above, the ALJ misinterpreted the progressive discipline provisions of the collective bargaining agreement, and respondent's offense being just cause under Florida law was sufficient grounds to terminate her employment. Based on the application of progressive discipline, the respondent's previous disciplinary record, her offense providing just cause, and the facts set forth in the record as articulated above, I believe the board should grant petitioner's exception number 2. As to petitioner's exception 3, the ALJ recommended that the school board, quote, carefully consider affording respondent, a 25-year employee, a chance to get back on track, end quote. The ALJ's recommendation here that the board should give respondent another chance should be rejected. In its findings of fact, as stated in my discussion of petitioner's exceptions 1 and 2, the ALJ has recognized that the respondent has had numerous past disciplinary issues as to which progressive discipline was afforded to her, including verbal warnings, written reprimands, and a 10-day suspension. Finally, the ALJ in paragraph 60 of the recommended order found that, as demonstrated by this case, in the absence of express list of progressive penalties for particular offenses, there are generally no hard and fast rules for progressive discipline. It is largely understood, again, that the employer retains a fair amount of discretion. Alternatively, as discussed above, the ALJ misinterpreted the progressive discipline provisions of the collective bargaining agreement. Respondent's offense being just cause under the Florida law was sufficient grounds to terminate her employment. Based on the application of progressive discipline, I believe that the superintendent's exception number 2 should be affirmed. As to petitioner's exception number 3, the ALJ recommended that the school board, backed up on that. Let me repeat the exception number 3. My pages are out of order here. As to petitioner's exception 3, the ALJ recommended that the school board carefully consider affording respondent, a 25-year employee, a chance to get back on track. The ALJ's recommendation here that the board should give respondent another chance should be rejected in its findings of fact as stated in my discussion of petitioner's exceptions 1 and 2. As to petitioner's exception 4, related to paragraph 73 of the recommended order, where the ALJ recommends an alternative to dismissal and allow the respondent to serve a significant period of unpaid suspension, contrary to this conclusion or recommended penalty, and based on the evidence as articulated in exceptions 1, 2, and 3, the next step in progressive discipline should be termination, not suspension. Consequently, I believe that the board should grant petitioner's exception number 4. As to petitioner's exception 5, related to paragraph 75 of the recommended order, where the ALJ recommends a period of unpaid suspension ranging from 20 to 30 days, based on the findings of fact I've articulated with respect to petitioner's exceptions 1 through 4, I believe the school board must reject the conclusion of law and/or recommended penalty in paragraph 75 and substitute the more reasonable conclusion that the next step in progressive discipline would be termination. Consequently, I believe the board should grant petitioner's exception to number 5. As to petitioner's last exception, number 6, again related to paragraph 73 of the recommended order, with respect to the ALJ's recommendation that the respondent serve a 20 to 30-day unpaid suspension, receive remedial training related to appropriate interactions with students, and serve a 6-month period of probation when she returns to work as a last chance to correct her conduct. For the same reasons I articulated with respect to petitioner's exceptions 1 through 5, the school board should reject the conclusions of law and/or recommended penalty in paragraph 73 and substitute the finding that the next step in progressive discipline would be termination. Consequently, I believe the board should grant petitioner's exception 6 and impose the penalty of termination instead of the recommended penalty of suspension. And after all of you are done, in summary, I believe the board should grant petitioner's exceptions 1 through 6 inclusive and deny each and every one of the respondent's exceptions. Vice Chairwoman Brew.
Thank you. So I was going to wait and see if other people had comments. I spent an incredible amount of time on and off going through all of the documentation that we have. Clearly, I'm not as articulate as you, Mr. Barbieri, or as detailed, but I'm prepared to offer up a motion that basically supports everything that you just said. So I'll wait to hear what my colleagues have to say, but I thank you for being so articulate and detailed.
Thank you. Ms. Whitfield.
Thank you very much. I just wanted to take a quick minute to review just a couple of things that I noticed in the paperwork. I, too, spent an incredible amount of time reading this documentation. And many times when we get a situation where we have a teacher that has, not been doing a great job, the documentation really isn't there on the level that we need to be able to ensure that this person does not come back to work for us. I felt the documentation was there in this binder that we had. One of the questions the ALJ posed was whether or not we had progressive discipline. And I felt that you could see progressive discipline through the entire document many, many times over. I'm sorry, I'm having a little voice issues today. And so looking at through the progressive discipline, I was actually somewhat horrified that we had kept her on as long as we did. So I think that the way that we need to move forward with this today, also I wanted to mention very quickly about the children. We had 5 videos of children that actually gave depositions, and I've given a few depositions, very, very, very stressful. I thought the children were unbelievably composed. They were so able to express what they had seen, remembering what had happened. They really did such an amazing job. I'm very sorry that we had to put them through that, but I felt like when you saw how honest and clear they were, there was no question in my mind that they were telling the truth. So I think an agreement with my 2 colleagues that have mentioned previously the way that they are planning on voting, I am either in favor, I would go on either one, of voting to grant all the exceptions that the superintendent has asked for, because I think that they make perfect sense. I do not want to see Ms. Baumann come back to work here. I believe in the termination that we gave previously. However, I would also be okay with remanding the case back to the ALJ to make additional findings if our legal counsel believes that's the more prudent course of action. Thank you so much.
Mrs. Andrews.
Thank you. I did spend quite a bit of time reviewing the file and having been in human resources for a while and looking at the case itself, just thinking about all of the times this district has worked with this employee to try to get her back on track, and progressive discipline, working closely with the Classroom Teachers Association, following the policies and procedures. I think it's evident in each one of the exceptions that we see here that the district has done everything that we could to save this teacher. I think at this point in time, it has been a long process with all of the children who were hurt through these processes, looking at the principals and everybody involved, and working through the process to keep her employed. We did the best that we could as a district. At this point in time, I certainly agree with my fellow board members that based on all the work that we have here and is truly documented, that I could not vote to bring her back in any instance. Thank you.
Go ahead, Ms. Brewer.
Thank you. So I'm going to make the motion, but I just want to thank everybody because I think we really have done our due diligence. I know that all of us spent a lot of time, and as Ms. Whitfield said, the documentation's there. We've gone through the process. I wouldn't support delaying this anymore, so I'm going to read the motion. I move that the board grant all of the petitioner's exceptions based on a complete review of the record and the reasons and citations set forth in petitioner's exceptions document and articulated by counsel at today's hearing, and deny all of the respondent's exceptions, and that the board authorize the general counsel to prepare a final order reflecting the board's rulings to be brought at the next meeting of the school board.
Motion, second, by Mrs. Whitfield. Discussion? Mr. Ferguson?
I think I may have overlooked something, but did the ALJ accept as fact the different incidents that we mentioned earlier in regard to the 10-day suspension, the written reprimands, the meetings with the principal at the time regarding conduct that this teacher committed on campus?
Yes, it's in paragraph, I believe it's in paragraph 14 of the ALJ's.
Okay. I'm looking, but just.
Yeah, it's in
I was
paragraph
kind of
14.
confused on that anyway, because, for example, the last 2 points, the 8/18/21, 12/17/21, it says he met with the respondent regarding respondent speaking loudly. So in my mind, I might be overanalyzing that. Did she agree that she did in fact speak loudly or allegedly threaten a student on those dates? And I'm just asking for my own clarification there.
Well, I mean, in paragraph 14, he cites that she received a 10-day suspension, that she also received a written reprimand and
See those?
another written reprimand.
Yep.
She does mention the other two items, but you're right, there's nothing other than those would be verbal warnings. I would suppose they would qualify as verbal warnings under the collective bargaining agreement.
Okay. All right.
General Counsel, is that correct? Those would be verbal warnings under when the principal calls a teacher in, those would be verbal warnings?
Yes.
Okay.
All right, is there any more discussion? All in favor? Opposed? Motion carries 6-0. Thank you all. We'll take a few minutes break. We'll start again at 2 o'clock after the superintendent can get rearranged and all the people we need to move where they need to move. 3 o'clock.